Our next topic is a topic that has generated interest both from PIABA, the plaintiff's bar, and also a lot of comments from at least 3 United States senators, and that's on the issue of expungement of adverse materials on the CRD reporting for registered representatives. Speaking today on this topic is Jeff Hines. Jeff is a partner with Goodell DeVries Leech, and he's going to review FINRA's amended approach to expungements over the past few years and the various rule changes that have culminated in the proposal to adopt FINRA Rule 2081. Among its other practice areas, Jeff defends broker-dealers and individual financial services professionals in customer disputes filed with FINRA, as well as investigations undertaken by FINRA. To that end, Jeff has prepared responses to FINRA's Enforcement Department and has defended respondents in Rule 8210 examinations. Please join me in welcoming Jeff Hines.
Good afternoon. I get the pleasure of being the first one to speak after lunch. We don't even have a full audience yet. I think we should make them feel bad. I like to start my presentations with a round of applause. Let's get ourselves woken up. This guy's great. I am a trial lawyer. So that means that I've tried cases in various jurisdictions, somewhere as far away as Arizona and New Mexico, handled legal malpractice, medical malpractice, pharmaceutical litigation, commercial disputes, whatever. But although I call myself a trial lawyer, a lot of what I do and a lot of what every lawyer does is settle cases. And it makes sense to settle cases. I mean, oftentimes there's the pressure upon your client. Your client doesn't want to go forward. Oftentimes it's tremendously expensive to litigate the case. Oftentimes you're going to lose, so you might as well buy your way out of it. And so we all are business people and trying to resolve cases. And what I want to talk to you today about is FINRA's expungement policy and rules and how it's been developed, because what's happening is it's going to become more difficult to get expungements, and as a result of that, it's going to become more difficult to resolve claims. So you guys are familiar with the Central Registration Depository. That's where the information is kept about claims against registered representatives and other financial advisors. Over the years, it's gotten broader and it's including more information. For instance, in the last 5 years, it used to be if you sued a firm and you didn't sue the registered representative and you resolved that case, nothing went on the registered representative's CRD. That's been changed, so now even if you're not named in the complaint, your information is still reported to the CRD, and as a result of that, through the FINRA website, BrokerCheck, a potential client is able to go on and get that information and find out if you've been sued. Now, I want to talk to you a little bit about a case history. This is a case that I had, and there's actually at least one person in the room who was involved in adjusting the case, but we won't talk about that now. The broker was sued in excess of 30 times. Same investment vehicle, we don't need to go into that now. And we won the first arbitration. Now, we won it in part because we had a very favorable petitioner for us. It was a middle-aged woman. She was very, very intelligent. She had a history of investment experience, and our broker had really, really good notes. So we won that case. However, there were 29 more cases, and some of those cases, the petitioner was much more sympathetic, not as intelligent, older, notes not as good. So we wanted to get out of the litigation if we could. The sheer fact that we had 29 additional claims probably meant that we would lose 1 or 2, no matter how superb that I was, that we would actually go down. So we wanted to get rid of the cases. They were brought by 2 law firms, and we had pretty good relationships with them. And we sort of went through the cases, and I thought we could get a lot of them resolved for under $25,000. There were some that were a little higher than that. The problem was the broker wouldn't do it unless he could get expungement. in which case, if we had to go forward on all 29 claims, you're talking about quite a bit of money, but he was willing to do it because he was a solo practitioner. If he didn't defend himself, he was afraid he'd be out of business anyway. So this briefly is the U4 disclosure requirements. We had to report. It was a customer-initiated claim. It involved an investment vehicle. He was named as a respondent. It alleged bad sales practices, and the settlement was going to be greater than $15,000. So we had to plan the resolution of these cases to get expungement. Now, FINRA has long described the expungement framework as an extraordinary remedy. Not true. Maybe true now, but wasn't true before. If you knew what to do, you pretty much could get expungement. At least 90-95% chance you could get expungement. And it was the recipe. So what you would do is you would get a settlement agreement. And in that settlement agreement, you would get the petitioner to agree that they would not show up and challenge the expungement proceeding. In fact, they wouldn't show up at the proceeding at all. And you would then present the facts that you wanted to present to the panel. Sometimes we'd even get them to execute an affidavit acknowledging that their claim was not so good. And we'd go forward and we'd get the panel to recommend expungement. Now, what you then need to do, this is Rule 280, which is the rule about expungement, and I'm looking at the bottom 3 lines, and what we were dealing with is what you have to do is you have to go to a court of competent jurisdictions, a state court or federal court, and they confirm the arbitration award that contains the expungement relief. In our particular case, we would go to the United States District Court for the District of Columbia because we found a particular judge that was favorable to us, and we would get these orders confirmed. Now, the real difficulty in what you need to do is you need to make sure that FINRA doesn't show up and be against getting an expungement. So what you do, the rules, and they still have this, the rules say that if the claim is found to be clearly erroneous, or that the registered rep wasn't involved in the sale, or that the claim was false, that FINRA won't show up and challenge the request for the court at competent jurisdiction to get expungement. Now, FINRA takes the position that those are the only 3 bases to get an expungement. That is, clearly erroneous, not involved, information is false. I don't think that's true. I think when you read the rule itself, and this is right below the section we looked at before, and it says if the expungement relief is based on arbitral findings other than those described above, which is clearly erroneous, not involved, false, then FINRA can still waive its participation under certain circumstances. So the rule clearly contemplates that the panel can expunge your record or order expungement other than those 3 grounds. But for practical purposes and practical reasons, you had to make sure you had one of those 3 because you wanted to buy in and get FINRA's cooperation. So in our case, we were able to settle the 29 additional cases. We were able to get them all expunged. We were able to save a tremendous amount of money on the policy, and we were able to save a lot of money on expenses, and our guy went on his own way. We call that a tremendous success story. I don't know what the public calls it, and I'm sure that Piava would call it something else. But our job is to represent our client to the best extent we can. Well, possibly such conduct resulted in some abuses. Piava did an expungement study. It was published in 2013. And during the particular period, January 07 to 09, expungement was granted about 89% of the cases where expungement was sought. As a result of this, FINRA sort of pushed back a little bit, and in 2008, they came up with a new system or new requirements the arbiters had to do, and they had to review the settlement documents, they reviewed the amount of the money that was paid, they had to state the grounds for their expungement, and it had to be one of the 3 that was listed in Rule 2080. This did not affect anything. I guess the greatest impact was number 2, which was the panel got to see the amount of money that the case was settled for. It's very hard to argue that it's a clearly erroneous claim it's false or your guy wasn't involved if you're paying $300,000 to settle a case. So it did have some sort of impact. But the panel, for most part, and I guess because they're used to dealing with firms like Larry's, they believe that to litigate a case is going to cost hundreds and hundreds of thousands of dollars. I'm just kidding. And so they would actually, we found as long as the settlement was under $100,000, the panel was perfectly willing to say, hey, we find it was clearly erroneous, or we found that it was false, and they would go forward and allow us to get expungement. So it really didn't affect business as usual, and in fact, PIABA's expungement study says that it was granted almost 97% of the time. Well, what happens is PIABA in 2013 began making a big push, a big clamor based on their study about how unfair this was, and that unscrupulous defense attorneys should not be able to go in there and buy expungement and buy cooperation. And so they published statements like this. Now, it's very, very hypocritical for them to make this statement. Larry actually wrote an article, and I want to give credit to his associate who helped him. It's Avital Stadler. I said it correctly, right? Close. Close enough. And he's the gentleman that went in and he looked at some of this data, and he found that in the cases where there was expungement, PIABA's own attorneys did not challenge the expungement over 95% of the time. So when they're on the case, they just want to get the case settled too. They don't want to go forward. They don't want to have the case expunged. And yet they come out and they make these statements that somehow, hey, this conduct's awful. This conduct that I participate in is terrible. Please make it stop. Well, they could make it stop anytime they want. The rules allow that. They could show up. They could participate in the hearing. They choose not to do so, and then they try to ride the white horse off into the distance. I got a problem with them, but you may know that. So anyway, what else happened, okay? Congress gets involved, okay? And so Congress, on December 16, 2013, Senator Jack Reed and Congressman Charles Grassley, they write a letter to Richard Ketchum, Chairman, Chief Executive Officer of FINRA, and they're shocked. They're shocked that 96% of cases where expungement sought, people get expungement. And so they ask, FINRA to take some steps to put a stop to this. And what has happened as a result of that is FINRA first announced that we're not going to allow expungement, we don't want expungement should be allowed unless it has no meaningful investor protection or regulatory value. Now, this is a nice statement here. It's totally unsupported by the rule. It's grafting another requirement onto the expungement process that's never gone through the rule-making process or authority. It's wrong, and this is the thing that's going to prevent expungements the most, not the new rule change, and we'll talk about that in a little bit. FINRA Rule 2081, when we first did this program, it was proposed. It's now been approved as of the end of July. So you can no longer get a settlement agreement that specifically says, hey, you agree to consent to expungement, you agree not to show up. We never did, and I don't think anybody ever did, put actual dollar figure in the settlement agreement for paying for the right to get expungement, but that's precluded too if anybody ever did that. So that's out. So what do you do now? Well, I think in your settlement agreements, what you do is you first put in what you're not doing. You're going to seek expungement, but you're not, because you haven't paid any consideration, and it's not a condition of settlement. That's what you're now going to put in. Okay? Is that in and of itself going to prevent resolving cases, the rule 2081? I don't think so, because it's the same thing as what's going to happen. I work with a lot of petitioner counsel, okay? You get to know them, and they have multiple cases. And they don't have to say certain things for you to know that if they take certain actions in a case, then next time you're going to take certain actions in response to them. I mean, they want to resolve cases. They want to work with you in the future. So it's going to be very rare that you actually have, I think, you actually have a petitioner show up and fight an expungement. I just don't think that's going to happen. there's nothing in the rule also that precludes you from having the plaintiff execute an affidavit, saying things like, we've been through mediation, we've been through discovery. As a result of this discovery process and as a result of mediation, I now believe that my claims, are meritless, or whatever language you want to put in. There's nothing in the rule that prevents you from doing that. You're still going to go forward before the panel. The panel's still going to be deciding it based on the record that you give them, the record the respondent gives them. So I don't think the rule itself is going to change anything. What I do think is a problem is how FINRA is now taking this additional requirement and imposing it on the expungement process. And what I've got up here is this is the FINRA dispute resolution guidance that's given out. What happens is when you're an arbiter, you're given this sort of checklist, and it goes through and says, do you fine for the petitioner? How much do you fine for? And you go in and you get to a section called expungement. And right in that section, it says information should be expunged only when it has no meaningful investor protection or regulatory value. That's before your panel now, and that's what they're being trained as. FINRA has started training their arbiters. You can go on and you can look at the program as to what they do with regard to expungement. And this no meaningful investment value is something that's being stressed to them. And it used to be, if you could get yourself in one of those three findings, that it was either clearly erroneous, it was false, or you weren't involved, you could get expungement. Now, I mean, it's possible you could have someone, theoretically, you could have someone that was wrongfully named in the complaint. It was not his investment vehicle at all. He gave no advice whatsoever, and that wouldn't be expunged because somebody on the panel thought the mere filing and the information was somehow something that would promote investment value. Now, that's sort of an absurd example, but there's no guidance to these arbiters. There's none given as to what it means. And it's another obstacle that you have to overcome, and it's one that's never been approved and never been subject to the rulemaking authority. So I'm not sure this is a particularly good solution. I think it discourages settlements. It forces arbitrations. I think you're going to have more claims. It's not the law. It irritates me that, if PIABA wanted to do something, it could participate in the procedures that are currently before that are currently enacted. And I think Larry made a good point in his article that, they have the right to show up and argue that things shouldn't be expunged. They don't avail themselves of that right because there's no additional money in it for them. And they don't have a desire to really help the public in an individual case. And they're worried that maybe they won't be able to settle cases in the future. So there is something out there available, and I don't think it needs to be changed. Now, one solution could be to train the arbiters, but that means train them fairly. Don't train them one-sided as to what FINRA believes is appropriate for expungement. Expungement is based on equitable principles. What's fair under the circumstances and the facts and circumstances of each case, and that ought to be up to the panel to make that decision. I think there should be a fulsome inquiry. You shouldn't be able to get it with the ease that we had gotten in its past, but there ought to be a better solution than the solution that they're coming up with now. And in addition, if we continue to see expungements, because I imagine that PIABA is going to continue to track this, there's additional things that are being requested. One is that FINRA will actually enter and participate directly in the expungement proceeding. FINRA doesn't want to do that. Richard Ketchum wrote that they don't think it's appropriate for them to actively involve themselves in a private contractual arbitration, but that's one of the things that's been suggested. So anyway, it's a good idea to keep your eye on this. I think it's something that you need to deal with in your policies, unless you have a policy that you can force your insured to take whatever settlement's offered, and I don't know whether you do or you don't. But if you have to get his consent, expungements should not be as easy to get now as they have been in the past. Anyway, thank you very much for your time. I appreciate getting the opportunity to speak with you. Thanks.